Beatties Ford Road appears consistently on Charlotte's high injury network, a city designation identifying the small fraction of roads responsible for the majority of traffic deaths and serious injuries. It's one of the most dangerous corridors in the city for pedestrians, and the reasons why are not random. Hi, I'm Michael Harman, a North Carolina personal injury lawyer, and I want to explain what makes this road so dangerous and what the law says when someone is killed or seriously injured on a corridor with this kind of documented history. The high injury network in Charlotte represents less than 5% of the city's streets, but accounts for the majority of fatal and serious injury crashes. Beatties Ford Road lands on that list because of a combination of factors that compound each other. High posted speed limits, long stretches without marked crosswalks, inadequate lighting, and heavy vehicle traffic moving fast through an area with significant pedestrian activity creates conditions where a fatal accident is not a matter of if, it's a matter of when. The city's own data reflects that reality, and it has for years. When a pedestrian is killed on a road like this, the legal conversation doesn't stop with the driver who struck them. The city and the North Carolina Department of Transportation have a legal obligation to maintain reasonably safe road conditions. And when a corridor has a documented history of fatalities and known dangerous conditions go unaddressed, that obligation becomes legally relevant. Pursuing a legal claim against a government entity is significantly more difficult than a standard personal injury claim, and success depends heavily on the specific facts. But a road with this kind of persistent, documented history is exactly the situation where that avenue is worth understanding and exploring alongside a claim against the at-fault driver. A claim against a government entity in North Carolina looks very different from a standard personal injury claim. It requires formal written notice within 90 days, follows a separate procedural path, and the evidence that matters most is the documented history of the road itself. Prior fatalities, prior complaints, prior engineering studies, and any internal city communications about known hazards on that corridor all become part of building the argument that the dangerous conditions were known and ignored. For families dealing with a loss on a road like this, the steps taken immediately matter. The physical evidence at the scene, any available traffic or surveillance camera footage, and the official record of what the city knew about that corridor before the accident are all time sensitive. That information doesn't stay available indefinitely, and the 90-day notice window to preserve a government claim starts from the date of the incident.